The Protection of Women from Sexual Harassment Act 2013, which is acronymed as POSH, is a landmark legislation in India aimed at ensuring a safe and respectful workspace for women. Its ambit covers workplaces across sectors, including government, private entities, and NGOs. However, recent debates have brought in attention to the exclusion of political parties from its scope, sparking discussions on whether the POSH Act should be expanded to include them. The lack of a formal redressal mechanism under the POSH Act within political parties has raised concerns about accountability and the protection of women working in political spheres. Expanding the POSH Act to political parties would align with its core objective of safeguarding women's rights and dignity in all workplaces. In this edition of the Roundtable, organized by Nicholden Times Gender and Society Cluster, we will be discussing the recent debate which has come up through a plea filed at the Apex Court. So, opening up the floor with the first question, which is a very basic one. What does the POSH Act entail and how are the redressal mechanisms incorporated within it? Yes, Anidhi, please go ahead.
So POSH Act 2013 came into being after, as a result of, firstly, the discussion started when the Vishakha guidelines came into being, and then they were extended to the POSH Act of 2013. Like when we talk about Prevention of Sexual Harassment Act, particularly in workplace, it was initially the case of Vishakha versus State versus Rajasthan, wherein NGO, like a social worker, was Banwari Devi, was assaulted while with during her work hours while she was uh, actively protesting. I'm not sure again something, but due to that, the Vishakha guidelines that was for the protection of women in workplace came into being, which was further converted, like which was further expanded to form the POSH Act that was implemented in 2013, and it basically gives guidelines for companies, and they're like specific numbers, as in the number of women if there are in a particular company, then there has to be an internal uh, committee that has to be set up, which includes a certain number of women from the administration who then have to hear complaints, internal complaint committee, who then has to hear the complaints that are relevant, like that are related to harassment in workplace, and this includes all kind of harassment. But to date, it is a very people try to sort of find loopholes within the to establish such a committee and for the enforcement of this act in various companies by primarily putting employing less number of women so that they do not have to follow such regulations that have been put forth in them. And then there are like various companies which do take up the front that they are not as big, and that's like a major loophole in the act itself, because a woman, whether working in a institution that has 10 people or 50, if they suffer harassment or if they are harassed in any way, then they are not safeguard in a particular scenario, they're not safeguarded under the act, so they practically have no recourse to law uh, in terms of harassment in workplace. That's essentially what POSH Act is.
Also, to add something is that the POSH Act actually states it's no woman shall be subjected to any kind of sexual harassment at the workplace. So it's very specific to women. And also, like when we were talking about, as Nidhi was talking about the internal committee, so these internal committee is set up if and only if there is like 10 or more employees. And also this POSH Act, and one and another aspect is that the POSH Act is required to be implemented both in public and private workplaces, and there is a need to set up internal complaints committee uh, to hear about these sexual harassments.
To add on to everybody's points, the POSH Act is basically providing a mechanism for redressal of victims of sexual harassment. Sexual harassment is also defined in the POSH Act. And the internal complaints committee is basically responsible for conducting preliminary inquiries and, if necessary, a detailed investigation into the complaint itself. And only if they find these allegations to be true will it attempt to conciliate between the complainant and the respondent. But however, this conciliation again cannot be imposed on the complainant. Furthermore, like if the conciliation fails, then the ICC may recommend disciplinary action against the respondent, such as like suspension, termination of employment, or other appropriate action. As regards the legal recourse or judicial through formal judicial process, if the complainant is not satisfied with the outcome of the ICC proceedings, they may approach the appropriate court or tribunal for further legal recourse. And also, like generally talking about the act, one is that it defines sexual harassment, which is basically broadly encompassing a range of behaviors, including physical contact and advances, as well as demand or request for sexual favors, or sexually colored remarks, showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. Furthermore, the procedure for filing and investigating complaints is also outlined within the Act, and the ICC is responsible for conducting a thorough and impartial inquiry into the complaint. The POSH Act also talks about the importance of creating a safe and respectable work environment through awareness programs and preventative measures. And the employers are required to organize these workshops and training programs to sensitize employees on issues related to sexual harassment. But however, as Sunidhi and Teresa have said, there are still practical gaps with the application of this act.
Moving on to the second question, how did the current debate of expansion of the ambit of POSH Act come into being?
I think one of the major things was that the definition of workplace and employee within the act has been very expansive over the time. Even when the Bhanbari Devi case had occurred, there was this argument of what could constitute as a workplace, because where the crime occurred in her instance also was very debatable as to whether that was her workplace or not, whether the area where she was protesting, or I don't exactly remember the nuances, but yeah, there was some spark of debate even then as to what would constitute as a workplace to ensure that POSH applies there. So there has been like a lot of expansive definitions of a workplace within the act as well, and the courts have been interpretive in that way too. In the particular case of like whether political parties could be in the ambit of a workplace has been a gray area over the recent PIL that has been filed, because the representatives have said that basically the Representation of People's Act covers political parties that are registered, and it can be considered as a part of what a workplace could be, but that has its own like backlashes, because again, where the activity is occurring and what the event where it's happening, it's very difficult to determine it exactly, which is why it has been difficult to really like apply the POSH Act to like political parties. So that is one thing which we need to consider.
So the current debate arose due to the Yogmaya MG versus Union of India PIL that we are talking about in this discussion, that was heard by Supreme Court on 9 December 2024, and they prayed for the expansion of POSH to political parties by making the redressal mechanism of IAC mandatory in political parties. They demanded for the uh, workers and candidates of parties to be declared as employees and employers. And they also questioned the 2022 Kerala judgment that declared that no employer-employee relationship exists in a political party. They argued that the exclusion leaves women vulnerable to harassment and abuse. It also leaves them at a double disadvantage, as they don't have access to remedy that other working women have. The absence also contributes to a culture of impunity, where the victims may be discouraged from approaching and reporting the abuse. The lack of transparency, inconsistent structures, inadequate internal mechanisms leave women vulnerable to exploitation and harassment. They gave examples of big national political parties like AAP that lacks transparency and BJP and Congress that admitted to not having an IIC structure. Only CPM has an IIC structure with external members.
Yeah, moving on to the next question. Briefly mention what was the Supreme Court's take on the aforementioned. Any one of you can go ahead.
So the Supreme Court, they referred to the 2022 Kerala judgment that I mentioned before and did not really expand on the POSH case. They focused on the procedural technicality and dismissed the case for approaching to the competent authority under the Representation of People Act, which is the ECI Election Commission of India, and while also opening a door to recourse to them if they are not satisfied. In my opinion, political parties are defined as associations of people under the Act, which excludes them from the definition of workplace and an organization under the POSH Act. So the political parties, they have a hierarchy which is mentioned in the party rules that can help in defining who is the employer and who is the employee. Therefore, it is also is, therefore it also establishes an unequal power dynamics with the possibility of a gender power play in motion. Even though these political parties already have disciplinary committees, there is no scope of sexual harassment or oppression of women. So, thus, the protection of female safety, equality, and their interest is deeply neglected. So, I feel that there should be either a separate enactment or the scope of the act should be expanded.
Regarding the reference to the EC, I think the Supreme Court has basically said that while this is an important issue and an important subject, they said that the competent authority to decide this would be the Election Commission, and only if there was no satisfactory answer that was got from them could they approach the court again, which again I think is a very time-consuming process where the Supreme Court itself could have probably given maybe some directive or some answer rather than referencing the election commission only to open up the chance for appeal later on. Furthermore, I think that the data also speaks for itself. While they said that political parties were not competent, like it was not a competent enough relationship between employer and employee. I think the facts itself, like the statistics that were brought up in the election commission itself, speak for themselves, and I think that it is an important issue. And I think that the Supreme Court could have done a little more or provided a bit more direction for how the law is to be interpreted.
I think I agree with Nidhi on this because when we talk about EC being the correct body to approach for such purposes, that is merely it's all. I would like to draw the analogy that it's almost similar to though any company or any workplace has been incorporated maybe under a Companies Act or an LLP or any other act that's required, but when we talk about what is happening with the employees in there, or when we are actually on a broader phase talking about the citizens who are a part of any institution in there, it is the court has would have complete jurisdiction, or maybe say an expanded jurisdiction in this matter, especially when it's a writ petition, and uh, any right to safeguard one's right to safeguards one dignity and honor is also a part of a fundamental right under Article 21. So I think the court had enough power and enough discretion to take up this matter rather than to put it to the EC, because eventually EC is a quasi judiciary, not even a statutory body, which is only working towards the procedure and the technicality of technicality of an election under which a political party is formed essentially, but that does not mean that the people within the political party would also fall under the purview of the EC, because the question of law over here is very different from what the EC would essentially look into.
Also, I mean, it runs very contrary to the very recent, like, other order of the Supreme Court of like having the ICCs, the internal committees being set up in like all government departments. The court had recently ordered that there should be an ICC in all government departments in states and union territories. Like, it should be mandatory to have them. And this really, like, not involving political parties under this ambit takes away the entire idea of like having women a safe space to participate in politics as a whole. And when the Supreme Court has in one case ordered it to be done in governmentally ruled departments and everything, then that should have been, the courts could have interpreted it by using the golden rule of interpretation that it should be also be done within political parties. I mean, time and again, we have had very expansive definitions of workplaces of employers and employees. It does not have to be restricted to dictionary meanings of the words, but rather what suits the context matters at hand. And I believe like sending it to the ECI is just again delegating the responsibility that the courts have much more power to like uphold.
And adding on to this from like a more moral or an ethical standpoint, like from the time of like the drafters to now, there's been a rapid transgression of like public perspective on what a basic unit of government is. And while that initially used to be individual candidates, more recently we're seeing political parties to be the basic unit or the fundamental units that comprise governments. And if we're not able to set a positive precedent within these units itself, then there's kind of a question up in the air of how are we supposed to impose these standards on governments at large. So I think when we talk about setting positive precedents and increasing accountability, it has to start from those grassroots units so that we can eventually reach a larger stage or set up governments that are also have their own inherent like they have their own inherent responsibility and accountability at the end.
And I feel like because of the reason he said that it's deeply related to the lawmakers and the parliament, I feel like the judiciary doesn't want to interfere too much, as it could lead to a breach of separation of power. And moreover, the point of a PIL is that you can approach the Supreme Court directly for the troubles of the masses. And here, by sending it back to the ECI, they're kind of making the PIL redundant.
A very quick point before moving on to the next question. In my opinion, political spaces are too bound to protect the dignity of women, and they should also, bound themselves within the realms of the POSH Act, because there are so many mainstream parties in India, and only CPIM has confessed to having an ICC, and the Aam Aadmi Party lacks transparency, whereas the INC and the BJP have allegedly confessed to not having a proper structure for ICC. And moving on to our last question, are there any instances that might have sparked this current debate? Any instances recent or past?
So I think this one instance wherein the PA of some Aam Aadmi Party leader was there who claimed to have, I think Swati, I don't remember the last name, Miss Swati Mahajan or something like that. She went to the ex-CM's residence, and his PA, she claimed that allegedly his PA sort of assaulted her for her to like meet the CM, and there was like a huge uh, question on the credibility of the CM, and what transpired within the CM residence. So that is one instance that I remember. Uh, that was right before the ex-CM was like arrested for like other charges, and no one knows if like there was no proof, or like there was nothing that came nothing concrete that came out to be, but it just became a piece of media or a piece of, I would say, TRPs, because after a certain time no one sort of followed it and no one knows what exactly transpired in that case.
There was a recent survey done by the Amnesty International, which was on online harassment that female politicians face. And they noticed that the Indian female leaders face twice as much as harassment as that in UK and US. And in case of marginalized castes, it's 59% more likely, and in Muslim women, it's 55% more likely. So there is a double discrimination on the basis of caste and gender, and on the basis of the religion and gender. And then I also read somewhere that if they speak against it, then the whole gang of the politicians will like oppress them and like just stop them from voicing anything.
There
Um,
was
it,
this. Go
sorry.
ahead.
Yeah, so last week, I mean, in 2023, when the Women's Reservation Bill was being passed in both houses of Parliament, there have been several complaints or MPs who voiced concerns about the fact that many members have serious cases of crimes against women pending amongst them. And I think the statistics for that were released by The Hindu, which says that over 860 serious charges are pending against 194 MPs before the polls itself. And over 20 of these MPs had pending charges of involvement in crimes against women, and four of which were rape. Furthermore, a lot of references have been made to, I think, Sharan Singh, who was the former president of the Wrestling Federation of India, and the Trinamool Congress has actually accused the BJP of not taking action against MPs accused of sexual harassment, citing the case of Sharan Singh. So I think also in a more general aspect, the Me Too movement that's come out and that's been trending in the last couple of years, that is basically so many instances of sexual harassment within political parties and political spaces in general have come out. And I think if you see the increasing participation of women within these political spaces over the years, um, all these stories I think are have all contributed to this petition that has come out recently, and I think it's all owed to the increasing awareness and the political space that these women have to talk about their experiences, which has led to the petition that we're discussing today.
Another
Adding to
instance, another instance was back in 2014 when an actor turned politician Nagma was allegedly groped and kissed by, a Congress MLA, and she had reacted upon that by slapping that person and then leaving the event. So again, this raises questions on, in such unfortunate events, how is the victim going to get the redressal properly if there is no committee to handle such matters, if there is no like a proper mechanism to deal with this as such? Because it's very easy for such male perpetrators to get away with it and apologize it when the time is convenient, when they have to garner more votes and support. But what happens on a more systemic level, that is something that needs to be discussed, and it can be understood through this unfortunate case that happened with Nagma, that in front of like crowds of people, something like this could have happened. So there's a possibility of many more events unfolding in these manners. So without the POSH being applicable, it's really difficult to like condemn all of these issues as well in the future.
And adding on to the Nidhi's point of Me Too movement, so even in Me Too movement, a lot of politicians did resign. However, not much media highlight was done on the female politicians. Like in the Bollywood, a lot of highlight was in the female actresses and what they said about, but not much was seen same in the political arena. And that is because it's also the women who have a deep patriarchal thinking, and the retaliation is much more serious in a political arena. So that also speaks a lot about the Indian scenario.
Yeah, and also the instances you guys have mentioned are not standalone instances, because there was this report by the Center for Social Research published in the Economic Times, which said nearly 50% of the respondents faced verbal abuse, 45% said physical violence and threats were common, particularly true during election campaigns, and 67% of the women politicians said that perpetrators were male contestants, and 58% of them were party colleagues. And this kind of violence also encourages dynastic politics, wherein only women from certain families who are politically elite come up to the political space actually, and inhibits opportunities for other women to participate in political spaces. So even though the Kerala High Court has ruled that, oh, that political parties cannot come up uh, within the definitions of a workplace, but still, I think political parties should be included within the realms of the POSH Act. And with this, I think we can conclude our roundtable for December if you guys don't have anything else to say. Thank you so much, everyone. Thank you for joining.